I'm WMUR political reporter John DeStaso. A setback at the State House for Marsy's Law, which would elevate the rights of crime victims to constitutional status equal to the rights of the accused. Wednesday, a House Supercommittee recommended the constitutional amendment not be put to voters after it had already passed the state Senate. The State House now will vote on that. Joining me today to discuss this issue are Stratford County Attorney Tom Velarde, who is a strong supporter, and Jeannie Hruska, Policy Director of the American Civil Liberties Union of New Hampshire, which is opposed to the current form of the proposal. Tom Velarde, New Hampshire has had a Victims' Bill of Rights in state statute since the early 1990s. Crime victims have testified, though, that they've not always been fully informed about the criminal justice process, and at times not even told about hearings regarding offenders' release or even an escape in a few cases. How would putting these provisions in the state constitution change that?
John, you're right. Victims' rights have been codified in our RSAs, specifically RSA 21-M, for a number of years. I think it's important for folks to understand that the rights that are codified therein are two different kinds. There are procedural rights, and we heard a lot of testimony from folks who were not given their procedural rights, who are victim survivors of crime. And there really is no excuse for that. Those folks should have received the timely notice that they were entitled to under the statute. What I'm talking about and what I've been testifying about and why I continue to support the movement towards some constitutional protections for victim survivors of crime is that there are also some substantive rights that are contained in the Victims' Bill of Rights, as well as in 632-A:9, which specifically enshrines a speedy trial right for child victims of sexual abuse. So there are two different arguments here, two different tracks that I think people need to understand. Again, back to the procedural rights, no excuse for why those were not upheld, and when I heard those victim survivors testifying, I was not only very sorrowful for them, but frankly I was embarrassed as a prosecutor that those rights were not being given to them when they should have been. But the importance of some movement towards constitutionality of victims' rights has to do with what kind of traction are those rights given when push comes to shove in a courtroom? What I mean by that is if a victim's rights are always going to be statutory or based in a statute in New Hampshire, then of course they're going to be secondary to a defendant's enshrined constitutional rights. What I've been arguing is that there are some nuanced times and places where, due to extended delays in a criminal case, the victim's right to a speedy trial should be given some constitutional protection and thereby allow a judge to weigh constitutional right versus constitutional right, rather than always have the victim's right to a speedy trial be sacrificed on the altar of the defendant's constitutional right. And just one other point, John, a lot of people have been talking about equal rights. I don't see these necessarily as equal rights. I see them as comparative rights, because the defendant's rights that have been in our Constitution for 200 years will always be paramount, except in very rare circumstances when they should be competing against a victim's constitutional right, if we ever get that far. Okay,
and Jeannie Hruska, I've asked you to respond to that, but I also want to ask, one of the main objections seems to be that these rights for victims, putting them in the Constitution, would somehow infringe or affect the rights of the accused. Could you explain how that happens? I mean, on its face, if you read it, it doesn't address anything like that. But how could it possibly do that, in your opinion?
Yeah, so the ACLU's concern all along has been with the specific language of Marsy's Law. The language is very expansive and ambiguous, and it's nearly impossible to know how it will be implemented and how courts will interpret this incredibly expansive language. And we have concerns that the language will result in victims' rights conflicting with defendants' rights. If you would note, in our statute includes explicit language that says victims' rights shall be enforced to the extent that they do not violate defendants' constitutional rights. That language is not included in Marsy's Law. There's nothing in Marsy's Law that will protect defendants' constitutional rights. And our concern is in those circumstances where you have a victim's right conflict with a defendant's right, it's very unclear what a judge is supposed to do in that circumstance. And our concern is if a defendant's right ever loses in that situation, what the result is to actually strengthen the hand of government. Defendants' rights are rights against the state. And if a defendant's right ever loses, you are strengthening the hand of the prosecutor or of the state in that situation.
What's your thoughts about that, Mr. Velarde?
From my experience prosecuting these cases over close to 2 decades, I would say that, again, they're going to be nuanced and rare circumstances where victims should be allowed to have pressed for them their right to have substantive rights in the courtroom. If you talk to victim survivors of crime, you will hear, and I'm talking about in the trial context, you will hear from them over and over again, the playing field is so slanted towards the due process rights of the defendant. And again, I want to be cautious about my statements. It's supposed to be. The Constitution is designed to be that way. And as a prosecutor, I inform victim survivors and their families, this is how the court system works and how it needs to work in order to protect the rights of persons accused of crime. My advocacy of this movement is that I don't think that victims' rights need to be such second-class rights. They can be elevated to some point so that there can be a competing right in the right circumstances for a judge. And judges in New Hampshire are wise in their decisions that they make. They're paid to make these decisions. And I think in the right circumstance that there should be a competing right where a judge in the right instance can say, this case needs to move forward for the child victim, or under whatever other circumstance the judge feels that the victim's right should, in that case, trump the defendant's constitutional right. Again, a rare instance, but to say it's never going to happen, really what that does is it takes any teeth out of RSA 21M when you're actually trying to press those rights in a courtroom, because those rights will always be subservient in every single circumstance to a defendant's constitutional rights.
Taking a broader view, should there be, if there were more resources available, would there be such a need to elevate these rights into constitutional status? And by elevating these rights to constitutional status, do you feel that will result in more resources? If it's not being fully appreciated on the local level in statute, why would it be on the constitutional level?
Well, I remember when 21M was promulgated, it specifically excluded misdemeanors because of the resource issue and the concern that local police departments would not be able to provide the level of services that 21M would call for. Since that time, there have been great strides made in creating offices of victim assistance. I believe each of the 10 county attorney's offices does have those offices. The examples that we heard from victim survivors indicating that their rights were not given to them in a timely manner, I was somewhat relieved to hear at least there was nothing that was in the very short period of time from when we're talking about. So in other words, things that had happened 5-10 years before, so they were still painful to those particular victim survivors, but at least they were more historical anecdotes rather than this is what's happening in courtrooms now. So as far as the resources go, I don't see that the constitutionalization of victims' rights would have that great of an impact on the resource issue, because I think that has been addressed in superseding years.
And the governor has said that money's no object in this. What's your take on this concept? Is it a matter of money, or is it a matter to adequately address, these victims, or is it something more than that? Voters out there may have to make that decision in November.
I think money is certainly part of the discussion. As a constitutional amendment, there's no fiscal note tied to Marsy's Law. There's no additional resources coming in based on this constitutional amendment. So the state and counties will have to implement Marsy's Law with existing resources. And Marsy's Law will add misdemeanors to it, which is roughly 44,000 cases a year. And it includes a broader definition of victim. So it will apply to a significantly broader group of people that counties will now have to provide services to. So there is a financial component to this that should be considered by taxpayers.
And Jeannie, my last question really to you both is going to be, why not put this on the ballot? Why should this not go to the ballot and let the voters weigh these arguments. That's an argument that we've heard Wednesday at this committee several times.
I think what you've heard from representatives from both aisles is this is a bipartisan effort to support victims. Everybody supports victims. This is not a debate about who does and does not support victims. The issue is the specific language in Marsy's law. So the concern about sending it to the ballot is voters don't have a chance to edit the language. They can't sit in the ballot box and kind of line edit the language. The language has significant problems. And given that, I think a lot of representatives feel that the better chance is to take this down and work on improving our statute next session.
And Tom?
John, I want to echo a lot of what Jeannie just said, which is folks right down the line have been in support of the concept. And I am really excited about the possibility of retooling the concept so that it meets New Hampshire's expectations of what our Constitution should look like, so that everyone's rights are balanced appropriately. The governor has given great leadership and support on this. Our Attorney General and leaders from both houses. Everyone wants to get this done. I think it's time to get this done.